Hello guys, Assalamu alaikum. Welcome to Tort lecture of Occupiers Liability. As in previous lecture, we studied about Occupiers OLA and we studied two of the acts, 1957 Act and 1984 Act. We also studied that 1957 Act deals with the lawful visitors, or we can also call them simply visitors. And we studied that 1984 Act deals with trespassers who enter your land without your permission. Now, we will study in this lecture about how to solve a problem question. I will share three of the most important problems of 2019, and I have 2 more years of problems, solve problems against them. And first of all, going towards the ready-made structure of problems, we will know that what type of steps are needed in order to cover the tort law problem effectively. Basically, as I firstly stated that first of all, after reading the problem, you must analyze that whether the facts in the present in the problem question are these facts dealing with occupier's liability or not. The simple question is that step one is that whether the given facts fall under OLA or not. Okay, this is our first fact. This means that in order to check whether it falls under OLA or not, you should check that whether the injury caused or the damage caused to a person, whether it is due to the state of premises or not. If it is due to the state of premises and it includes in the premise, then facts fall under OLA. Moving on to the next step, you have stated that the facts fall under OLA. Now moving on, you will study that whether the injury caused to person B, the place where the injury has been caused, whether this place amounts to premise or not. We studied its definition that anything, any house, any movable or fixed structure, vessel, these all things amount to premise. And we also studied that ladder also amounts to a premise. So you have to check whether the injury caused is included in premise or not, the place is included in premise or not. Then moving on, you have to check whether the injury, you stated that the injury has been caused in the premise. Now, whether the premise is occupied by the person or not. Okay, whether the defendant occupies the premise or not, whether he is control or physical control of the premise or not, or the house or the office. If he is in physical control of that place, thus number 4 step is clear. Now, these all steps are like a type of step 1. Okay, I have divided into 3. Second, the condition of the problem starts here. You have to divide into 2 parts the problem. You have to check whether the facts or the scenario, the person who has been caused injury, whether he is a trespasser or a visitor. We also studied that visitor is a person who has been given a license or who is having an implied permission. Moreover, police and the firefighters have a legal right to visit your land without any permission. So these are included in visitors. Then trespasser is a person who enters your land without your permission, and he is having no express and neither implied permission. You have to check it. Then you have to check that whether you have the duty of care towards him or not. If you have duty of care, then you should check that whether you have fulfilled that duty, and if yes, then whether you have took any reasonable steps to avoid that person and injury, to avoid any injury to a person who is a visitor or trespasser. Then there is a separate situation for children, that you must care for children more than the adults. You, for example, if you care 50% for adults, so for children you should care about 80%. Then there is a separate situation of skilled worker, that whether the facts fall under skilled worker or a contractor. In this step, after this step, you have to choose that whether the person is a skilled worker, a child, or a contractor. Then according to that, you have to check whether the duty has been fulfilled, whether the reasonable steps has been taken. For example, in the case of a contractor and skilled worker, the reasonable steps are that you have to check whether the work he is doing is proper or not, and whether he is a skilled person or not. Then we apply the defenses, which is of non-fit injuria defense, and we are also having a defense of warning and exclusion liability defense. So these are the 3 defenses. So this is the overall, this is the structure of how to solve a problem question on occupiers liability. As firstly stated, that determine that whether the facts fall under OLA. If they fall under OLA, then check whether the place where the injury has been caused, does that place amount to a premise or not. Then check that the premise which injury where the the premise where the injury has been taken place, whether that premise is occupied by the defendant or not. If your answer is yes, then move on. Then check whether the person who has been caused injury, is he a visitor or a trespasser. After that, you have to come towards duty of care. Then in duty of care, you should check whether the person is a child, skilled worker, or a contractor. Out of that, if it is a skilled worker or a contractor, then you should apply your duty of care steps. And that then you should check reasonable steps and then apply the defenses if any applicable. Guys, coming to a solved problem question, which I have solved already. Coming to problem number 1. Let me make it a bit. Okay. This is a problem question from 2018 Zone A paper. Let's solve this problem. According to the problem, Chuan decided to build an extension to her house. What did he said? Decided he wanted to build an extension to the house. She contracted with Premier Construction Limited. Who is he? Independent contractor. Keep in mind, okay? Now the first situation deals with independent contractor. Before building the foundations for the building could be laid, a deep trench excavation was required, which needed inspection and approval by the council. At the start of the excavation work, PSL erected scaffolding and placed a notice at the entrance to PSCL is the Premier Construction. This is known as the person who has been independent contractor at the Chuan's house, and placed a notice at the entrance to Chuan house saying, danger, no admission to unauthorized persons. Okay, this has been the notice by the Chuan's contractors. Considering the principles of law which arise under the Occupiers Liability Acts of 1957 and 1984, if the injured parties attempt to recover the losses arising from the following incidents. Now we have the following incidents. And at first we stated that there is an independent contractor who is working in Chuan's house. He has also made a warning, which is that danger, no admission to unauthorized persons. Now coming to the situation. Number first situation is that Jin, the 2-year-old son of Chuan, was discovered lying badly injured in the excavation trench. Jin's, the 2-year-old son of Chuan, was discovered lying badly injured in the excavated trench. Now coming towards number first situation of Jin. Okay. Before going and solving a problem, you should study that this problem question deals with the occupier's liability, and it requires the question of Chuan that whether he could be liable for the incidents which occurred at his house during the ongoing instruction. And then you should study that whether the injuries caused to Jin, Nadeem, and Fred will are these under the occupier's liability crime or not. And we will also study that whether they fall under the 1957 Act or 1984 Act. Okay. Now coming towards the first problem of Jin. Number first question, as I stated in the previous lecture, that whether it falls under OLA or not. So let's check it. Whether the following, the actions which has been done on the injuries caused to Jin, whether these facts fall under OLA or not. According to this, I am here to advise the parties as to the liabilities under OLA 1957 and 1984. First of all, I will determine whether the facts fall under the scope of occupier's liability or not. This is our first step, okay? According to Section 1, Subsection 1 OLA 1957, it codified the common law rules which regulates the duty of an occupier premises toward office visitors in relation to the injury or damage caused by the dangers arising from state of premises. Now, this is the Section 1 of OLA 1957, which tells us about the injuries caused due to the visitors, and Section 1 of OLA 1984 states that injury caused to the trespassers. Now, as according to the case of Ogo versus Taylor, important case, if the injury is caused by the defendant instead of a state of premises, hence the liability will be under negligence estate. On the facts, now applying the facts to the two cases and the one case and the two laws, it can be said that the trench Jin fell into would be a mid-construction state of premise. Okay, now it is due to the state of premise. Okay, now thus fulfilling the Section 1 of the both acts. Before considering whether it falls into 1957 or 1984, we studied that according to the facts, the injury caused to the Jin is due to the premise, is due to the state of premise. Thus, it falls under OLA. Let me make it stay in the call. Okay, moving on. Our second step will be that whether the place of injury amounts to premise or not. Moving on to the second requirement, according to which the place of injury must amount, according to which place of injury must amount to the premise that can be occupied. Okay, this is the most important. According to the Section 1 OLA 1957 and Section 1 OLA 1984, a premise is a movable structure which may include vessels, aircrafts, vehicles, or houses, offices, factories, etc. Now, applying these two laws of Section 1, subsection 3, and Section 1, subsection 2 of OLA 1954, and now applying the facts into it, the trench Jin fell in was located in Chauhan's house, which would easily satisfy this definition. According to definition, anything which is included in a school, factory, and so forth amounts to premise. Thus, the injury has been caused at a trench which is located in a Chauhan's house. Thus, it amounts to premise. Moreover, in Higgs versus Foster, the place of injury was a pit on the defendant land as well. Now, in Higgs' case, it was decided that the pit also was included in premise. Thus, according to the facts, it is satisfied that the place of injury of Jin amounts to premise. Now, moving on to the next step. Now, it must be, the step is that whether the defendant now occupies the premises or not, whether the Chauhan occupies the premises or not. Now it must be said whether Chauhan comes with the definition of occupier. First of all, you will check that whether he ability of a person in occupation or control of the premises, or the other hand, section 1, subsection 2 of OLA 1954, it stated the liability of an occupier who owes duty towards visitor, as according to the case of Wheat Lecon, important case, okay? As any person with sufficient degree of control over the premises is an occupier, Now, this is the ratio of this case, that any person who is having control in a house, sufficient degree of control, so thus that person will be an occupier of that place. Moreover, Lord Denning clarified that by adding that it does not matter whether the owners were actually occupying the premises or not. On the facts, the premise concerned is Chauhan's house. Therefore, it can be presumed that she has the occupation or control of the house. When a person owns a house and living in that house, thus it means that he owns that and he occupies that house. Thus, our third step is also clear. Now, whether Jin is a visitor or a trespasser, this is the important fact. It must also be established whether Jin could be considered as a visitor or trespasser. Section 1, subsection 2 of OLA 1957 says that a lawful visitor is anyone who has permission to be on the premise. And since Jin is Chauhan's child, it is obvious that he is a visitor. Simple fact. Okay. Moving on now into the important factors of duty of care, that whether Chauhan is Chauhan who is the occupier, whether he should be responsible and whether he is having any duty of care towards his child who fell into the trench or not. In section 2, subsection 2, let me highlight it. This duty is to ensure that her visitor should be reasonably safe at the place of the premises. Moreover, the person who is an occupier within these facts here it is Chauhan, so he must be more careful than adults for the children's in the present which is in. And thus, according to this, he is having a duty of care towards Jin. Now we will check that whether that Chauhan has made or took any reasonable steps in order to have more care towards children or not. The next issue is that whether Chauhan has taken reasonable steps to cater for Jin's safety within the premises of shift the liabilities onto PCL. Now there are two types of facts. Number first, whether Chauhan will be responsible for Jin's safety and whether did he took any reasonable steps, and moreover, if he took reasonable steps, then whether the liability shifts into PCL or not. It should be noted that PCL is erected the scaffolding, but it does not mention about how they have been placed. Jin is a child and therefore can easily fit through a small opening and fall. It is unlikely that PCL be liable for the incident as an independent contractor. On the facts given that there is no detail on how scaffolding was erected, and there would be negligence on behalf of PCL. Even If PCL will be considered as occupied due to the control exercised over the construction, it can be occupied that Chuan has the parental responsibility to look after the 2 years old son. Let me make it clear to you all that we studied in the previous lecture that if there is no technical knowledge required and the owner has not took any reasonable steps, then the liability is upon the owner, not upon the contractors. Okay, thus the trench does not require any reasonable steps. Chuan could also know that my child could fall into this trench. Thus, as there is no um, trench required, thus up to this, now Chuan will be responsible for the injuries of his child. However, usually prudent parents would not allow a child to play in unsafe places like construction site in Jin's case. However, the following case of bone leisure, this is an important case, let me highlight it. Sorry. It is most likely that neither PCL nor Chuan would be liable, as it is recognized that sometimes children wander off and risk of injuries may be inevitable. Now, at last, I've stated that neither of them will be liable, just because in this case, the child might have wandered off, he might have been afraid, thus he fell into a trench. Now we have the next situation of Nadeem. A taxi driver ignored the sign at the entrance to one house and entered the driveway to turn his car around. A piece of scaffolding fell into his taxi and smashing the windscreen. This is an important fact. Yes, there is no personal injuries, but there is a property damage towards his car. Coming towards this, Nadeem versus Chauhan. Whether facts um, fall under this or not. As concerned Nadeem, the windscreen of his car was smashed while he entered the premises of Tuan House to turn his car. The loss arose from dangers of the condition on the premise and therefore can be eligible to make a claim against Chuan. Okay, simple that the claim is there. Now, occupier. On the facts given Chuan, we have already read that Chuan is an occupier and he occupies that place. Now, whether Nadeem is a lawful visitor or is he a trespasser? The main issue is that whether Nadeem is a lawful visitor or trespasser, because if he is a visitor, then Chauhan will owe him a duty of care, and hence he can claim for the broken windscreen. Okay. As a trespasser, under Section 1, subsection 8 UoL 1954, now if Nadeem is a trespasser, then he cannot claim his property damage. However, Nadeem could have argued that he was a contractual visitor. In Robson versus Hallett, it was held that generally the occupier of premise gives an applied permission to the members of the public on lawful business to come through the gate to make inquiries or ask for admissions. Additionally, since Nadeem is a taxi driver, if he was entering to the premise to pick or drop someone, he may have argued that he was a contractual visitor as per 1957. We can take him into the category of the person like postman who enters the house with an applied permission. So we can put Nadeem as a category of a visitor just because he had implied permission as a taxi driver to enter the house. However, he was in fact only on the premise to turn his car around, which likely means that he was exercising a right of way on one's premise. It is said that exercising a public and private right of way does not make one a lawful visitor under OLA, and therefore Nadeem will not likely be a visitor. Now, this states that when a person exercises public and private right and does not and in the house of another person, thus that person would not be regarded as a lawful visitor. This means that now he is a trespasser. Then we will look at whether is there any duty of Chauhan's towards a trespasser or not due to the property damage. Thus, it is clear that Nadeem is a trespasser. So, under Section 1, subsection 4 of OLA 1984, the occupier has the duty of care to non-visitors to ensure that he has not been injured. However, at the present situation, there is no injury done towards Nadeem. Moreover, there was a warning sign also placed. You can look at the warning access to an authorized person, and Chauhan may refuse accept liabilities from those people who are unauthorized. Just because the Nadeem was an unauthorized person and he fall under the category of trespassers. And there was a warning sign also placed. However, the danger was obvious as claim dived into depth of water. In case of Tomlinson versus Borough Council, this is the important case. Let me highlight it. The House of Lords rejected a Tomlinson claim on the basis that though he entered the premises lawfully, he threw himself into pool here where swimming was forbidden. Since the danger arose not from the state of lake but itself of the claimant's activity by ignoring the sign, thus there will be no liability of the occupier. Now applying the case of Tomlinson into the Nadeem situation, he by himself ignored the warning sign. Thus, he, after ignoring, he turned the taxi, which means the liability, there will be no liability upon Chauhan just because it was due to the own actions of Nadeem. Moreover, under section 1, subsection 3 and C, there will be no property damage given to a person who is a trespasser. As we have already studied that Nadeem is a trespasser, thus he cannot claim any property damage. This is clear law of fact. Okay. Coming towards last situation, Fred, an inspector from the council, arrived to inspect the trench excavation. Fred had smoked cannabis on his way to Chauhan's house, and even though trench supports that had not yet been fully set up, Fred climbed into the trench to measure its depth. He broke up arm when the trench collapsed. This is a very tough situation here. Whether the Fred falls under OLA, yes, he falls under OLA just because the injuries caused him were due to the state of premises. The second question is that Chauhan was the occupier. Then number thirdly, yeah, the Fred was having a implied permission just because he was a skilled visitor and he was an inspector from the council and he has an implied permission, he amounts to be a visitor. However, is there any duty of care of Chauhan's toward visitor or not? So there should be two questions now. There are two issues. Whether Chauhan has failed in exercising their duty of care or not, and whether Chauhan can argue that now as I have given the contract to PCL, so the duty of care lies on the PCL. Okay, the basic thing is that now two factors in order to discharge the Chauhan's claim into PCL, there will be two factors included. Whether Chauhan has made an inspection of it or not. So coming to it from the facts, Fred is a skillful visitor and therefore section 2 subsection 3 para B applies. Okay, it states that whether or not Chauhan has been the duty of care, she may expect a skilled person like Fred when exercising your duty will be aware of the risks. Okay, we have the two cases. Now Chauhan might argue that he was a skilled person and he might know that whether this place amounts to a danger place and whether there are any risks of not. Then Chauhan can also argue that Fred should have noticed the trench was unsupported and therefore should pay a head before inspecting the depth. In Rule versus Nathan, Lord Denning pointed that occupier is not bound to watch over a skilled visitor, but that does not mean that occupier will be absolved of their duty. If the court finds that the Fred had exercised all necessary care and skill to guard against risk, then Chauhan will not be liable. However, here Chauhan did not make any guard against the risk, thus he would be liable. However, coming towards independent contractor liable, from the facts, it is clear that the PCL was in charge of that place now. So there will be three steps in order to prove the liability of PCL in order to discharge the liability of Chauhan. Number first, that it is reasonable to entrust the work, whether it was reasonable to give work to PCL or not, whether Chauhan did take any steps to ensure that the PCL was an competent company or not, and whether she took reasonable steps to verify that work was done properly or not. So the first and the second conditions are satisfied as there is no mention that there are no facts which doubts the competence of PCL. Okay. However, according to the last fact, there is nothing mentioned, I think, about the steps that Chauhan took in order to check and verify that whether the work done by PCL is done properly or not. So the issue with the third condition is that it is not expected for Chauhan to have knowledge and skills to check PCL's work, and thus this shifts the liability towards PCL. Now, PCL will argue that there was a danger sign at the entrance of Chauhan's house and they may discharge their duty from it. Now the duty has been shifted into PCL. They may claim that there was a danger sign placed and which stated that no admission to unauthorized person. However, Fred is an authorized person. That thing, warning sign, finished offense. But it should be noted that Fred was under the influence of cannabis, but did not mention about the quantity consumed. Therefore, it is more likely that the lack of concentration on behalf of Fred, based on the above factors, Joanne may discharge her duty of care to PCL or even Fred and hence not be liable of Fred injuries. However, if then a possible defense would be that of contributory possible negligence consent under Section 2. However, Chuans will not be liable just because he shifted his duty towards PCL. Moreover, PCL would also not be liable just because Fred was under influence of cannabis. Okay, now coming to the last situation, which is that let's see what is the paramedics arrived and administered emergency first aid before moving Fred to the ambulance to take him to the hospital. The paramedics forgot to warn Fred not to try stand up as the medicine he had given was likely to cause drowsiness. This is the fact number one, which is important. Fred was carrying a large quantity of cannabis in his pocket and he was afraid that might be discovered. When a paramedic attention was focused on packing up the first aid equipment, Fred attempted to climb out of the ambulance to dispose of the cannabis. Fred used the rear door of the ambulance, which was at a very high, steep down to the ground, and he fell and broken hip. Now, whether paramedics would be liable under OLA or not. So, the last point of issue concerns Fred and the paramedics. Fred received an emergency first aid, but the paramedics forgot. Is the important fact to warn him that not to stand up just because he may experience drowsiness due to the medicine which was given to him. In order to get rid of the cannabis, Fred made an attempt, and he was successful in that attempt in order to jump out of the ambulance. Thus, he fell down and he got a broken hip. Thus, according to the higher, it's more appropriate for Fred to make a claim against the paramedics under negligence rather than OLA, just because it does not fall under OLA. The injury caused to Fred is not from state of premises. It is clear that the paramedics offered him a duty of care and what the duty of care was breached, as they failed to warn him up not to stand up else and he will experience drowsiness. However, the main issue is that whether there is sufficient evidence that there was a breach in the duty of care on the behalf of paramedics or not. Now we will look at whether they did breach or not. The breach resulted in a broken hip and it is not remote as could be foreseen under the medication. However, the court may apply the defense of illegality in contributing negligence. These are the two defenses of the ambulance people who can say that there was illegality and the contributing negligence. The contributory negligence means that both actions on both sides were wrong, thus which resulted in the injury of that person, and it would be successful. Moreover, they would also claim that it was fault on behalf of him just because he ran out. So the elements must be proved. However, the thing again comes on to the ambulance paramedics just because they did not inform him about that. So in order to get out of that liability, the paramedics would have to raise this defense of contributory negligence, and it now depends upon the judges that whether they grant him exclusion of liability or not. This was the problem question, and it's a very easy problem which deals with the four situations. First situation we dealt with Jin, and then the second situation we dealt with Nadeem, and third was about Fred, who was inspector and got a broken arm. Then paramedics, due to which there was a broken hip of Fred. This was the problem question of OLA. Mostly, what I suggest that first of all attend the battery problem question, then attempt OLA problem question. Just because the problem question of OLA is long and lengthy, and the problem question of nuisance and battery are very short as compared to these. Thank you for watching the lecture.